शुभ सकाल सबको। आज पूरे भारत में हिंदी दिवस मनाया जा रहा है, हिंदी पखवाड़ा मनाया जा रहा है। तो हम आज का ये सेशन जो है आईसीआर सिरकॉट की तरफ से रफ्तार ईबीआई जो है हमारा, उसकी तरफ से एक सेशन अरेंज किया हुआ है, गेस्ट लेक्चर। आज का गेस्ट लेक्चर का टॉपिक है इंटेलेक्चुअल प्रॉपर्टी के ऊपर। और हमें आज गेस्ट हैं मिस्टर रोहिणी पायल, जो कि सीनियर आईपी एडवाइजर हैं गोदावरी बायो रिफाइनरीज लिमिटेड कंपनी में। उनका मैं थोड़ा सा बैकग्राउंड देना चाहूंगा आज के इस सेशन में। उनका उच्च शिक्षण पोस्ट ग्रेजुएशन हुआ है इन एग्रीकल्चर केमिस्ट्री, पीजी डिप्लोमा इन इंटेलेक्चुअल प्रॉपर्टी मैनेजमेंट, and then she is also a patent agent authorized government of India's patent agent is she has qualified and various certification in intellectual property rights from World Intellectual Property WIPO, which is one of the world intellectual property organization, which is a good authority where madam has got qualified. The core expertise I would like to mention some core expertise from madam as intellectual property rights में उन्होंने patent, trademark, copyright, laws, एडमिनिस्ट्रेटिव प्रोसीजर्स, लीगल एनालिसिस ये चीजों पे काम किया हुआ है। उसके अलावा आईपी ड्यू डिलिजेंस, स्ट्रेटेजी डेवलपमेंट, आईपी सपोर्ट टू ऑनगोइंग आर&डी एंड बिजनेस प्रोजेक्ट्स, आईपी बजटिंग एंड मेंटेनेंस, आईपी कॉन्फिडेंशियलिटी मैनेजमेंट प्रोसेस, इन सभी के ऊपर उन्होंने लीगली काम किया हुआ है। उसके अलावा नेशनल बायोडाइवर्सिटी अथॉरिटी इश्यूज भी उन्होंने इश्यूज और अप्रूवल्स के ऊपर भी काम किया हुआ है। देन पेटेंट सर्च एनालिसिस, पेटेंटेबिलिटी एनालिसिस, क्लेम स्कोपिंग एंड प्रोसिक्यूशन सपोर्ट, इन चीजों में भी उन्होंने काम किया। आफ्टर दी व्हेन पेटेंट फाइल करने के बाद जो क्लेम की प्रोसेस रहते हैं, उसके अलावा प्रोसीडिंग की प्रोसेस रहते हैं इन कोर्ट, वो भी उन्होंने किया हुआ है। इवेल्युएटिंग टेक्नोलॉजी ऑन द बेसिस ऑफ द पोटेंशियल ऑफ फॉर कमर्शियलाइजेशन एंड टेक्नोलॉजी ट्रांसफर। आईपी जो है इंटेलेक्चुअल प्रॉपर्टी, उसके अलावा उन्होंने आईपी कमर्शियलाइजेशन एंड टेक्नोलॉजी ट्रांसफर के ऊपर भी उनका एक्सपीरियंस है। शी हैज अ मोर देन 13 years of experience in intellectual property domain, and she is expert in this particular domain from past 13 years. We are very pleasure to have the guest like this expertise. वेलकम मैडम ऑन दी दिस प्लेटफॉर्म। आपको मैं अभी आपकी तरफ अनुरोध करता हूँ कि आप सेशन को स्टार्ट करिएगा।
Yeah, thank you so much. Thanks a lot. Especially for the introduction in Hindi. आज हिंदी दिवस के उपलक्ष्य में ये योग बना है कि मेरा लेक्चर मैं आप सब लोगों को आई विल बी एड्रेसिंग ऑल ऑफ यू, एंड मैं कोशिश करूंगी कि मैं भी ज्यादा से ज्यादा हिंदी में आज बात कर लूं, बिकॉज सिंस वी आर सेलिब्रेटिंग अवर हिंदी डे। सो थैंक यू सो मच। एंड अभी मैं स्क्रीन शेयर कर लेती हूँ। एक छोटा सा पीपीटी बनाया है, पीपीटी है जिसमें सारी बेसिक इंफॉर्मेशन रिगार्डिंग आईपी दी हुई है। लेकिन मैं चाहती हूँ कि बिकॉज आईपी जो है इट इज नॉट अ सब्जेक्ट फॉर स्टडी पर से, ठीक है। इसका पढ़ाई या उसके बारे में बहुत ज्यादा जानकारी इकट्ठी करने की, उसके बेसिक समझ अगर है तो द नेक्स्ट इंपॉर्टेंट थिंग विच कम्स इन पिक्चर इज इम्प्लीमेंटेशन। एंड मैं चाहती हूँ कि ये इम्प्लीमेंटेशन पार्ट पर आप लोग जरा ज्यादा ध्यान दें, बिकॉज ऑल ऑफ यू आर डीलिंग विद डिफरेंट थिंग्स। आई हैव गॉन थ्रू द लिस्ट ऑफ योर ऑल द इंटरेस्टिंग थिंग्स ऑल द स्टार्टअप्स आर डूइंग, एंड मुझे लगता है कि आईपी आपके लिए बहुत इंपॉर्टेंट है, समझना भी और उसका उपयोग करना भी ठीक से। सो नाउ आई जस्ट शेयर माय स्क्रीन, शेयर करती हूँ मैं, और मेरा पीपीटी एक जो है पहले हम विल जस्ट गो थ्रू इट, एंड आई वुड लाइक टू कीप द सेशन वेरी इंटरेक्टिव। जस्ट अ मिनट।
हाँ, और एक पॉइंट मैं ऐड करना चाहूंगा मीनवाइल, आज हमारा सेशन जो है 1.5 घंटे का रहेगा, क्योंकि हम आज थोड़ा टाइम स्लॉट लिमिटेड है हमारे लिए। तो हम कोशिश करेंगे कि जल्दी क्वेश्चन एंड आंसर का भी पूरा समाधान हो सके।
हाँ, सो मैं मेरा पीपीटी ज्यादा टाइम पीपीटी पे ना स्पेंड करते हुए विल गिव मोर टाइम फॉर डिस्कशन। सो आई होप माय स्क्रीन इज विजिबल, सबको दिख रहा है क्या?
यस यस मैडम, जस्ट मेक अ स्लाइड शो।
ओके, या ओके, ठीक ठीक है, तो आज का अपना चर्चा का जो विषय है दैट इज इनोवेशन मैनेजमेंट, और पूरा एक स्टार्टअप पर्सपेक्टिव से सारी चीजें इसमें दी हुई है। तो जो की टेकअवेज या जो हम यहाँ से सीखने की कोशिश करेंगे दैट इज एक बेसिक आईपी का, आईपी के बारे में थोड़ा सा ज्ञान, अवेयरनेस, देन आईपी का क्या महत्व है, और आईपी का एक स्ट्रेटेजी या जो हमारा एक योजना है आईपी को यूज करने का विथ योर स्टार्टअप, वो हम उसके बारे में थोड़ी सी चर्चा करेंगे। एंड इफ टाइम परमिट्स आफ्टर दैट वन इशू, नेशनल बायोडाइवर्सिटी एक्ट, उसको हम एकदम ब्रीफली स्टडी करने की कोशिश करेंगे। सो बिफोर आई डाइव डीप इनटू आईपी के टाइप्स और बौद्धिक संपदा के जो अलग अलग तरह के अधिकार दिए हैं भारत सरकार ने, वो बिफोर आई डाइव डीप इन दैट, let me tell you कि why intellectual property has become important over a period of time. So intellectual property, अगर हम लोग ठीक से अगर हम देखते हैं, अपनी हिस्ट्री का स्टडी करते हैं, तो जो एक प्री इंडस्ट्रियल इरा था, मे बी वी कैन से बिफोर वर्ल्ड वॉर फर्स्ट और सेकेंड, तो उसमें सबसे ज्यादा कंपोनेंट जो होता था वो होता था लेबर, बिकॉज बहुत बड़ी बड़ी मशीन्स होती थी। उसके बाद जो इंडस्ट्रियलिस्ट थे दैट इज द कैपिटल, एंड उसके बाद आता था नॉलेज कंपोनेंट। सो द प्री इंडस्ट्रियल इरा वाज डोमिनेंट बाय द लेबर पार्ट। ओके, द इंडस्ट्रियल इरा, इफ यू सी द लेबर पार्ट, although it is there, but capital investment part has increased and also has increased the knowledge part. But in today's knowledge economy, we know that knowledge is the most dominant factor in today's industry, apart from the capital, that is the investment, and then comes the labor part. So ये जो एक knowledge का महत्व बड़ा है over a period of time, ऐसा क्यों हुआ? What has caused this transition? So एक वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन है जिसके अंडर बहुत सारी ट्रीटीज साइन हुई है। सो इफ यू सी, आई गिवन हियर, there is GATT, that is General Agreement in Tariff and Trade. There is GATS, General Agreement of Trade in Services, and there is TRIPS, that is Trade Related Aspects on Intellectual Property Rights. So because these treaties are existing on the international level, and because India has signed all these treaties, it is under obligation to open its boundaries for foreign players also. So there is an increase in international flow of goods, services, and knowledge. So because the boundaries have now become very porous, हम लोग एक जगह बैठ के ये नहीं सोच सकते कि okay, I'm doing very good with my startup, my idea is very innovative and no one can create competition for me. So this thought should not be there in the mind, because competition can come not only from the national level, but you can see many international players who scout for startups ideas all over the world and implement them on their own levels. So ये था एक background कि why IP or knowledge component is becoming very important. I'll just move to the next slide. Yeah. So now what are the challenges which are triggered due to trade liberalization? So we understand that because of signing of so many treaties, the trade has been liberalized. The Indian government has to give equal opportunity to the Indians as well as any person all across the globe who wants to do business in India, because they have signed the treaty. So what are the challenges as a businessman, as a startup creator, as a creator of some kind of implementing some idea, unique idea through a startup? You should be very well aware that the startup has to generate in the shortest possible time, because things are moving at a very fast pace all over the world. They have to generate the things in a cost-effective manner. Okay, incremental improvements through sustained R&D efforts is the key to remaining consistent in the market. once a product is created, you have to keep on innovating around them, making it best suitable to changing circumstances. So these incremental advances are very much required, and there should be a robust mechanism to protect the intellectual property since the beginning. So the key lies in having the product to the market at which is cheaper, faster, and better over the existing product. So this is the mantra for a successful startup. Now, today's lecture will cover from this the robust mechanism to protect intellectual property. This part would be discussed in today's lecture. So I always keep this slide to understand what level of knowledge or what level of awareness is there amongst the participants about intellectual property. So if I am audible properly, and if you're seeing my screen right now, do you see any problem in this slide? Any one of you? Is there any problem in the slide?
Yes, hello, ma'am.
No, ma'am, there's no problem. We can see.
Yeah. No, you can see the slide. I'm
Yes,
asking content
there
of the slide.
he want their patent for a copyright and trademark, and both are have the different IP standard. The patent is one of the type of IP, copyright is one of the type of IP, and
Right.
trademark is one type of IP.
Yes, very good. So this is what I actually wanted to know, the level of awareness, because what happens now when we say about IP, people are only patent comes to the mind of most of the people. Okay, this is even people say that this is a patented recipe or this is a patented name. So patent is the only form of IP which most people are aware of. So you are very correct, because these are all different types of IP rights which have different thresholds of registration. So one by one, we'll go through it.
Hello?
Yeah. Hello?
Are you asking any question to me?
Sorry?
Are you asking a question to me? No, no?
No.
Okay.
Okay.
Sorry.
I was very happy with the answer. That's it. Okay. So intellectual property. So what exactly is intellectual property? Intellectual property is something which has been created by human mind. Okay. Tangible property is something which we all are aware of, a piece of land or building, or a piece of jewelry which can be traded off for some amount of money or some other favor. But intellectual property we cannot see. We cannot see intellectual property, but it is a property which is created by human intellect, by the input from some human intellect. Now, we cannot see the property. So how that property can be protected and how it can be used for generation of some revenue or some business. So to address these issues, these IP rights come in picture. So what are IP rights? IP rights are the rights which are conferred by the government of India for protection of your intangible assets, for protection of your intellectual property. So here I am covering only the 4 types of IPRs which are very relevant from business point of view. Of course, there are many more, there is GI, that is geographical indication, which is given for a group of people from certain places. I'm not covering those, only patents, trademarks, designs, and copyrights, which are very relevant for a startup. These will study in detail. Also, there are some non-registered forms of IP. So what are non-registered forms of IP which you manage at your own levels? There is no procedure involved, there are no documentation involved, no application, no prosecution, no grant. Okay, so still it is a form of intellectual property. Which is this? The trade secrets. Okay, technology know-how, the NDAs, non-disclosure agreements, lists, there are market understanding, there are employee contracts, there are suppliers, etc. All this makes your IP inventory. Okay, because you have spent your time in understanding the market situation, you have created some trade secrets, some procedures which you are following to attract more business, okay, and technology know-how, client list, all these are non-registered forms of IP, and these make a part of your IP inventory. I'm moving to the next slide now. Yeah. So this is a basket wherein all the forms of IP are, and I tried to explain what are different types of IP or tools and how, because there has to be a combination when you choose any of these tools. So patents, I'll just speak about the basics. If anyone has any particular question, please feel free to ask. So patents protect your inventions or innovations for 20 years. It requires full disclosure of your intellectual property in the public domain. It has a very stringent procedure for registration. There are many stages involved, and it is quite an expensive procedure to file a patent. So patents, then trademarks. Trademark you can file for any marks or words. We are familiar with many trademarks. Forthcoming slides, I'll give you some examples also. So trademarks are the perpetual IP rights. I mean, you get it for the completely throughout the years. Only thing is, once it is registered, you need to renew the register after every 10 years. Okay, and it can be extended infinitely. It is not so in the case of patents, because after 20 years, you will lose your right on the invention. The patent will be open for public to use the invention. Trademarks registration is required. There is a certain formal procedure of registration, but it is not mandatory. You can start using the trademark without any formal procedure. Only thing is, it should not be similar to any trademark which is existing in the market. It should not happen that you are infringing on someone else's trademark. Then there is copyright. We all of us are familiar with this type of right. It is for artistic work. There are many types of copyrights actually: cinematography, artistic, author. So different angles are there in the copyright registration, and it is accorded for a lifetime of author plus 50 years. After that, it loses the right. Again, in copyright registration, formal registration is not required. In Indian copyright law states that once a thing of art is created, the person or the artist has his right on it automatically. Only thing is, if if the matter goes in some dispute, then it is better to have a registered copyright certificate to fight your case in the court of law. Now, industrial design is one form of IP which is given again for 10 years, and it has less stringent criteria. It has less stringent criteria. It is given only for the design, design of a product, like a Coca-Cola bottle, or if someone has maybe some machine, some startup has a machine designed for some purpose, they can protect the design of the machine. These patents protect the process and the product, but industrial design protects only the outer appearance of the product. So this is also helpful in many cases, depending on the thing where it is being used. Registration is mandatory. And I have already talked about trade secrets. So trade secrets are the secrets which a person manages at his own level. It is simply a secret. Only you can, if you are confident that you will be able to keep the process or whatever trade secret subject is there as a secret, and there is no leakage, you are strong enough to keep it as a secret, you can opt for the trade secret type. Here, no registration is required, no expenditure, nothing. Only disadvantage is if it is stolen. Sorry. If it is stolen or if it is copied, you do not have anything in your hand to stop that person from working on your trademarks. Trade secrets. Yes. Now, patent. Because I have seen many startups who are working on some processes, or no, composting ka hai, then cellulose sheet mass I have seen, or mycelium packaging, spraying machine procedure, etc. So I thought of patentability just to let you know how and when you can file a patent. If you think that that your invention is novel, it is non-obvious, and it is capable of industrial application, then you can go ahead and file a patent application. Apart from this, if some technical advancement and economic significance is noticed over the existing technology, it is called inventive step in the IP space, then also you can attempt filing a patent application. Okay. So I am not going in details, but if any one of you has any questions about these thresholds or anything else, do let me know, or we can discuss. Okay, now from a startup perspective, this is a very important slide because here I am giving the details of a very good scheme, that is a startups intellectual property protection scheme, which is implemented by the government of India. And recently, like, it was till March 2023, but now it has again been extended for 3 years. So what are the highlights of this? The startup can use panel of facilitators which the scheme has to assist IP application filing. Here the government bears the facilitation cost. What is the facilitation cost here? The professional fees from the attorneys. Because if I tell you the market situation, suppose if the government fee of filing a patent application is 8,000, or for a startup it becomes very less, that is 4,000 or 2,000 depending on applicant status, then the attorney fees is around 40 to 50,000. So these fees is being borne by the government. Only the startup has to pay fees of filing, the government fees of filing the applications. So, and there is also reduced fee structure, as I told you. Okay, so there are facilitator panel for patents. There is a facilitator panel for trademarks as well. And this all details of the scheme are available. I have given here the link on IP India government's website. Now so where does the IP gets created? At which stage? IP through creation to commercialization. So right from the start, here you can see IP adds value at every stage, from creative innovative idea to putting a new, better, cheaper product service in the market. So when your startup is at the idea stage, you can think about a patent, confidentiality or non-disclosure agreements. They have to be very strongly executed. When the idea moves to the research stage, of course, nowadays it is not possible to do the entire research by a single entity. Many partners are involved. There's this era is of open innovation, like there's a give and take of results, or all the test or collaboration. So in here, don't enter into any collaboration or any assignment of rights, or do not share any information until you have your collaborative research agreements, which status or the assignment of rights or patents, or who all will be the applicants, who all will be the inventors, and all these background agreements should be in place. Because these things seem very minor and we often ignore, but this becomes very important few years down the line when the startups take some shape, or even I will discuss it in the future slides. Then again, patent, trade secret, and at the time of market launch, it is very important to create the brands and technology licensing agreements. And so this knowledge is very important as you move ahead. Now, there's always a conflict, because what is the difference? Why startups and IP do not go hand in hand? Okay, there is always a conflict, and why I'll tell you. Startups का जो एक focus होता है, generally it is very short term focus, because they are always are very low on funds, or low on resources, they are low on the staffs. So their short term focus is to survive in the market. Okay. They are driven by the market needs. Suppose if some market and the products or processes are customized according to the market needs, always. Revenue generation objective is often for survival in the market. Okay. And resource constraint, they are always resource constraint, I already told. Whereas when we talk about intellectual property in any form is a long-term commitment. Okay. It is bound by IP laws. It requires formal procedures, documentation, and expenditure. Okay. IP does not help in directly making revenue. It is not that you file a patent application and it generates some revenue for you. It is not like that. So there are some ways in which the IP has to be leveraged. Okay. And it is a slow and expensive process. Lots of patience is required. But let me tell you, everything few years down the line, this would be your biggest assets in the market. Your valuation, if you do not protect your IP properly, then your valuation, and when you protect your IP properly, then your valuation, there would be a huge difference few years down the line. So be very much aware of these things. So as I told you, IP does not generate revenue directly. Okay. Then how IP gets converted to why we say that it is a valuable asset? What is the return on investment when we talk about IP? So the major uses which IP is put is using it for self FTO. Now, what is FTO? FTO is one thing which allows you to do business in the market with a free mind. FTO is freedom to operate. Now, what is freedom to operate? Suppose I have an invention in my hand, I have worked on it, मैंने मेरा process use किया, मैंने मेरा product भी बना लिया, and I launched also in the market. But there is some person who already has that kind of product in the market through the similar kind of procedure. So he can come, he can stand up and he can stop you from doing your business at any stage. So all your efforts put in developing the business will go as a waste. So how to avoid this? To have your own patent application. So you can show, this is my legal right. I have it in my hand. I'm not in how different my invention is. I'm not infringing on anybody else's IP. So this freedom to operate is a very important asset which is generated through a patented technology. It reduces the risk of infringing on others' IP. It increases barrier for competition. Suppose you have a very unique product in your hands and it is very well, the patent application is drafted in such a way that it covers all aspects, then the competitor will not be able to enter in your space, at least for 20 years. After that, anyways, the shelf life in today's world, it is very less for any type of invention. So you will get enough time to leverage your invention. Okay. It records respect and it increases the company valuation immensely. Okay. Because for example, if I can give here, I see cellulose sheet mask, which can be used for cosmetic purpose. One of the startup is doing business, is involved in this thing. So if your IP is very well protected, and if tomorrow you want to sell off your technology to someone, many cosmetic companies, suppose L'Oreal is doing very good business with cellulose, they are using bio-based material in their cosmetics. They have a very strong policy for that. So you will get a very good return for your startup. So this is the kind of rewards you will get through your IP protection. Another thing is licensing. You can license out, as I told. There is one thing called enforced licensing. Enforced licensing is you have your patent, you have your product, and you find out, instead of anyone else finding out that you are not doing the right thing, you find out that someone is infringing your IP. So instead of going into litigation, what you can do, you can go there and you ask them that you pay me certain amount of royalty and okay, go on using. So it depends, like when you are in a position to negotiate, and there you can form a cross licensing model in which your IP and others' IP can be combined to create something new in the for the market. Now, how IP strategy for a startup can be devised? So these are the basic questions which are always being asked: why, what, and how to protect. So these are all the things I have told you in detail: patent, trademark, trade secrets. So you need to decide how to blend various forms and come up with a overall robust protection for your business. So think about expenditure, think about the timeline, think about so many things. Think about industry vertical, horizontal. It helps in understanding business stakeholders. Suppose tomorrow you want to integrate your business vertically, or you would like to go horizontally and collaborate with some other players in the market. You want to go B2B or B2C. Okay, so if you want business to business, then you need not generate any brand as such. But you should have your technology protected through a patent. But if you want to go B2C, I have seen one startup which is engaged in creating some bags and totes and from natural fibers. So that is B2C. Fine. So here it makes sense that the person creates a brand for that. So here the trademarks will come in picture more than patents or copyrights for this thing. So this way you think and blend these various forms of IP. Then what are your business goals or objectives? Whether these are short term, you want to sell off your venture to some investor, or is it a long term? If long term, then you need to file for some expensive forms of IP or robust protection. If it is short term, then your goals will be different. Now, what would be the exit stage? As I told, acquisitions or mergers or even IPO. What are the future possible dynamics which you are thinking about your startup? And for that, what kind of IP portfolio or IP inventory should be managed at your end? And the business model. So the business model, current and envisaged. So today, what is your strategy? And tomorrow, how you would like to expand? So all these things should be kept in mind, and an individual IP strategy should be devised. So here I'm just giving an example of a small IP which has generated lakhs of revenue for the creator. So the inventor license system, this is about the can opener. Just the click of the can, when it is opens, the inventor license system Coca-Cola at one.
We have to 4,000 square foot, 4,000 kilometer per hour. Hazards per
Okay. So
please
the
mute all
inventor
participants.
license.
Sorry, please mute all participants. Yeah, madam, please continue. Sorry for that.
No, it's okay. So the inventor licensed the system to Coca-Cola at 1/10 of a penny per can. So the power of licensing, the power of having something in your hand which can generate so much in the future. So because he had the patent in his hand, during the period of validity of the patent, the inventor obtained these many UK pounds a day on royalties. So just imagine the power of having a registered form of IP. Now, what would be the suppose if you want to bring in some investor on the board, so what would be his interest from IP point of view, or otherwise also visibility in the market? So visibility, if it is a B2C, how known your brand is in the market. So that is visibility. For that, you'll have to have a proper brand, a robust IP portfolio covering all aspects, timeline of protection, like what is the timeline? Suppose if you file a patent today and after 10 years some investor come on board, he will definitely see okay, only 10 years of the patent life is remaining. So that would be a consideration from his part. Multi-dimensional or 360-degree coverage of the IP, and the scope of protection, like of only filing a patent application would not be sufficient. उन claims में क्या ठीक से cover किया है सारे parts, because claim is one part of patent which actually gives you the right. उसमें जो लिखा है ना उतना ही आपको मिलेगा through that patent. Suppose you forget a very important parameter, putting a very important parameter in the claim, then you will lose your right on that parameter. So this is a claim is one important part of a patent application. So here in this slide, I'm just showing how different this, suppose Canon camera, of course, these are not being used in, this is a very old technology, but for an example, it is a good subject. So I given the autofocus mechanism is patented. The brand name Canon, all of us familiar about, is patented through a trademark. And the design, external appearance, is patented through the design registration. So you can combine all this together and create a good IP basket for your product or process. So I think regarding IP, I covered almost all the important parameters. And Biodiversity Act is one thing which a startup has to be aware about if they are using a bioresource. Okay, so I think most of the startups are based, because agriculture based, so biodiversity comes in picture. And these slides, they contain the information. So Biodiversity Act 2002 has been implemented in India, wherein there are certain protocols which are to be followed if you are using a bioresource for creation of bioresource for research or commercial utilization. Of course, a multinational company has different laws, I mean, different compliances, and a startup would have different compliances. A startup which does not have foreign participation, of course, it will fall under the State Biodiversity Board, and the mandates are different. So I will not go in details of this, because these are just for awareness for all the startups. And yeah, there are certain exclusions available. Those are given in this slide. And these are important definitions which come under the Act. And why should we should be aware of the Act? This slide covers that. If you have any questions, just let me know. We can go in details. And yes, Section 7 of the Biodiversity Act is for the Indian entities, and it says that the prior intimation to State Biodiversity Board for obtaining biological resources for certain purposes is required. Okay, the definition is given under this of Section 7, and these are the consequences of non-compliance. I may also add that the Act is under amendment right now, and we are expecting some good provisions to come up. It is under discussion, and in this Act, so we are hopeful that some good things would come up, which would be good from the business point of view. These are some of the case law example. And here I come to the end of the presentation, and I would tell all of you to monitor, manage, and evolve through your intellectual property. So this brings me to the end of the presentation, and now I would like to have any questions, because that would be more helpful than this. Yeah. Thank you so much.
All the participants, you can ask and raise the questions regarding the intellectual property, the madam has said. सभी participants अभी आप questions के लिए open हैं. आप अभी question and answer session लेंगे.
मिस्टर गणेश.
हेलो, ये मैडम.
यस सर.
रोहिणी मैडम, आप थोड़ा ये जो गवर्नमेंट ऑफ इंडिया अभी दिया ना स्टार्टअप को, थोड़ा दिया शॉर्ट टाइम में उनका ये मैंने अप्रूव होता है, और उनका फैसिलिटी क्या है इसका बारे में थोड़ा आपको बताना है, क्योंकि आज डीपीआईआईटी कुछ ऐसा प्रोविजन किया जिसका ऊपर स्टार्टअप को थोड़ा प्रिविलेज मिलता है. समझ गए ना. उनको 6 महीने में ग्रांट होता है, ऐसे कुछ होता है.
क्या
क्योंकि
सर?
मेरा
मैं इसके ऊपर एक ऐड करना चाहूंगा सर पॉइंट. महाराष्ट्र स्टेट इनोवेशन सोसाइटी जो है हमारी, स्टेट नोडल इंस्टीट्यूट ऑफ इनोवेशन सोसाइटी, लाइक इनोवेशन में, उन्होंने अभी उनका स्कीम लॉन्च किया है. जो भी पेटेंट जो फाइल करते हैं, पेटेंट पूरा फाइल होने के बाद वो पूरा रिम्बर्समेंट क्लेम कर सकते हैं. फॉर एग्जांपल, उनको खर्चा आया है 1 लाख 1.5 लाख तक ग्रांट होने तक का, तो वो फाइल वो महाराष्ट्र स्टेट इनोवेशन के सोसाइटी के पोर्टल के ऊपर अपलोड करके वो रिम्बर्समेंट ले सकते हैं.
नहीं, वो तो है किंतु लेकिन उनको सब्सिडाइज रेट में ये पेटेंट मिलता है, और पेटेंट का जो पीरियड है ना, तो मेरे को लगता है स्टार्टअप के लिए बहुत कम है.
प्रोसिक्यूशन का सर? प्रोसिक्यूशन का?
यस मैडम.
Sir, the scheme is to facilitate the startups for technical and financial input. It does not actually per se help because the prosecution will take its own course actually. There are provisions of early examination, early publication, so they may be guided to file those applications and get the prosecution at an early stage. But the scheme does not, at least this startup intellectual property protection scheme does not mention any expedited prosecution by default for startups.
ओके, एक्चुअली आज यू आर आवर रिसोर्स पर्सन रोहिणी मैडम। मैं क्या करता हूँ ना, मैं आपको थोड़ा रिसोर्स पर्सन हिसाब से हमारा एबीएम में इंक्लूड करता हूँ, और उदय उदय को बोलता आपको इंक्लूड करने के लिए, सो दैट यू विल जस्ट गाइड आवर पीपुल, सो दैट द मिनिमल चार्ज रहेगा ना आपको वो सब लोग को देंगे, बिकॉज वी आर फंडिंग नीड। जो आपको पैसा रहेगा ना थोड़ा सा नॉमिनल रहेगा ना, दैट दे विल रिम्बर्स टू। ओके, आई विल मेक दैट। ओके, आई विल मेक दैट थिंग। I will make that.
Yeah, anytime.
Okay. Okay. Any question answer? You start with Rohini madam, please. All startups, I'm requesting you.
Madam, I have a question.
Yeah, tell me.
Myself Ganesh ma'am. मैं सुपारी का जो बाई प्रोडक्ट आता है, जो फार्मर प्रोसेस करते हैं, उसके बाद जो बाई प्रोडक्ट मिलता है, उसको इस्तेमाल करके हमने एक प्रोसेस बनाया है जिसका हमने इंटरनेशनल पेटेंट अप्लाई भी किया है, उसका इंटरनेशनल एक्सेस भी हमें मिला है। इंडियन पेटेंट भी हमको क्लियर होगा, पर उन्होंने ये बोला कि नेशनल बायोडाइवर्सिटी बोर्ड का अप्रूवल ले लो करके।
जी जी, वो लेना पड़ेगा सर, लेना पड़ेगा।
तो एग्रो बाई प्रोडक्ट के लिए भी वो लगेगा ना? अभी हमने फिलहाल हम क्योंकि कर्नाटका से ये रॉ मटेरियल ले रहे हैं, तो कर्नाटका बायोडाइवर्सिटी बोर्ड को हमने अभी एक एनओसी के लिए एप्लीकेशन दिया है। वो नेशनल बायोडाइवर्सिटी,
सॉरी, या टेल मी।
वो उनकी एनओसी नेशनल बायोडाइवर्सिटी बोर्ड वाले अप्रूवल के लिए मांग रहे हैं।
आपने एनबीए में अप्लाई कर दिया? एनबीए को एप्लीकेशन कर दिया, रिलेवेंट फॉर्म?
एनबीए का एप्लीकेशन कर दिया
ना?
फॉर्म 3।
हाँ, so then they will the due course will happen, and then you'll get you'll have to sign the agreement basically, and you'll have to provide to the patent office. So in your case, the patent is ready for a grant. Only thing remaining is NBA's approval. So once you get the approval, you will get a grant in India as well, no issue. And then you can, can always use it for your business.
और मैडम दूसरा सवाल ये है कि अभी जो प्रोसेस बनाया हुआ है, अभी हमने एप्लीकेशन भी निकाला है, उसका एप्लीकेशन का अभी टेस्टिंग चल रहा है, पर एप्लीकेशन का अलग से पेटेंट बनाना पड़ेगा ना? अभी प्रोसेस पेटेंट का उसको ऐड ऑन कर सकते हैं?
ऐड भी कर सकते हैं, एंड डिपेंडिंग इफ यू आर इंटरेस्टेड, यू कैन क्रिएट अ सब्जेक्ट मैटर फॉर डिफरेंट पेटेंट एप्लीकेशन एज वेल, क्योंकि एप्लीकेशन बेस्ड है। सो डिपेंडिंग, अगर आपको नया पेटेंट ऑफ एडिशन भी कर सकते हैं, देयर इज अ टाइमलाइन विद इन व्हिच यू कैन। कब फाइल किया था आपने ये वाला?
दिस इज बिफोर 22 months.
22 months, ना? So I think better एप्लीकेशन बेस्ड पेटेंट फाइल करना ज्यादा बेटर रहेगा, मुझे लगता है। इंडियन पेटेंट,
सेपरेट पेटेंट। ओके,
so you have to create some substantial पूरा ये जो रहेगा ना आपका एप्लीकेशन का प्रोसीजर रहेगा, and you create some subject matter on which that can substantiate the patent application.
Okay, sure, thank you.
मिस इंदुमती।
हाँ मैडम, मेरा एक क्वेश्चन है।
हाँ सर।
आप बायो रिन्यूएबल एनर्जी में काम करते हैं, बराबर?
सर नहीं, इट इज नॉट बायो रिन्यूएबल एनर्जी। इज द पार्ट ऑफ इट इज अ एनर्जी जनरेशन, बट
नहीं, हम क्या करते थे, प्राज यूनिवर्सिटी का मैं कंसल्टेंट था, तभी मैं जो कॉर्न है ना, कॉर्न कॉप पूरे इंडिया में से सप्लाई करता था, और वो कॉर्न कॉप का पाउडर बनाते हैं और इथेनॉल सेपरेशन करते थे। तो और क्या कर सकते हैं बायो रिन्यूएबल एनर्जी में?
So this is actually not in today's lectures context, because my company and Praj's business interests are overlapping, so मैं ज्यादा तो नहीं बोल सकूंगी, But there are so many options available in the literature. You can always search. You can implement.
Okay.
Yeah.
Thank you.
Yeah. Anyone
Miss
else?
Indumati madam. Indumati madam.
Hello, sir. Hello, ma'am. I'm Indumati. We are
Yeah.
making biodegradable cups, ma'am. Sir, Ashok sir asked to take patent for our product, and we approached the consultant. But before that, we came in to know that the fabricator which gave us the machines, no, ma'am, he is also applied for a patent.
Oh.
He informed us that in that machine there is the possibility to make biodegradable cutleries or anything with 40 types of waste. But ours is a specific. We are making from sugar waste sugar cane. That is during the germination stage, no, ma'am. At that time, we used to extract the scoot in the bud, and the remaining portion of the stalk is used to make our product.
To which
Can you
product?
understand me?
Yeah. I'm following. Which product you're saying?
Biodegradable teacups.
From the part which is remaining after extraction of sugarcane?
Extraction of the bud chip.
Okay, the remaining part you're using for making your?
For making, only we use sugarcane at the early stage. That is at the 7th month
that is
of
the
age.
waste. Anyways, it goes as a waste?
No, that is very low sugar content, ma'am. So it can't be used for jaggery purpose.
Okay.
But there is some quantity of sugar is present in that. So we are not extracting the juice, and we are making a separate process, and we are using natural binders to make this. Whether if his patent will affect me, that is, he is patenting for his machine, but I am patenting for my product. Is it
your basically I think your interest is the process?
Process, ma'am. Process and the end product.
Product is the cups, na?
Yeah, ma'am.
Biodegradable cups. So I think biodegradable cups, if you see the prior art or the literature, what would be the novelty of aspect of cup? As the product, I'm saying.
As the product, I couldn't get you, ma'am.
So as a product, if you want to patent, na, it has to be novel. Okay.
Yeah, ma'am. Yeah.
So I feel that better than focusing on the product.
Okay, ma'am.
You can focus on the process.
Okay,
because see, patent ka threshold I told you. एक तो novelty is a must. Obviousness कि किसी को ऐसा नहीं लगना चाहिए कि यार ये तो बहुत easy है मैं भी कर लूँ.
Sorry to interruption. I don't know Hindi, ma'am.
अच्छा, okay. So see, novelty part, nothing exists in the prior art which you are trying to create. So that is novelty. Obviousness is any person who is working in your field. Suppose some raw material, anyone can create biodegradable cups. That is the today's very in thing.
Yes,
biodegradable based disposable material. Okay, so even we are working. One part of us is creation of that. We work with sugarcane. We work with the production of biodegradable tableware. Okay. So it's not a very unique idea. Okay. So what my opinion would be, rather than focusing on patenting the product, that your biodegradable cups, you focus on patenting the process through which you are creating. Because that would satisfy the patentability threshold. Okay. So
how long time I should wait to get my patent, ma'am, since I'm in startup stage? How long it will take?
See, patent prosecution, it depends on the subject matter. Suppose just like we file a patent, it goes in the patent office. Okay. And then if there are different segments or different subject divisions in the patent office, some are chemical waste, some are engineering, software, blah blah, and so on and so forth. So it depends on which domain your patent falls in. If there is a rush, if it is a heavily crowded subject like chemicals,
no, don't comes under chemical, ma'am. This is purely we are not using any chemical at any part.
So I'm just giving an example. So if it gets examined, it will get examined early if no rush is there. The examiners. Otherwise, it goes in the queue, and then when your number comes chronologically, then it gets examined. But see, don't wait for. It is not like you need to wait till grant of the patent. Once your patent is published and it gets published, it is in the public domain. It gives you a right which is as good as a granted patent.
Okay.
So
okay.
the
Mere
procedure.
filing will support me. Mere filing the patent and waiting for examination will support.
Yes,
it won't create any problem.
See, the date you file the patent makes a difference. That is called a priority date.
Okay, ma'am. Okay.
Suppose anyone wants to enter or has similar kind of technology, and if they file a patent earlier than you, then you will lose the right. Understand?
Okay.
So if today I file a patent and tomorrow someone else files a patent on my technology, because see, we never know how many people are working on similar things, no? So the priority date makes a difference, because the earlier priority date will get the right.
Is it a disclosure agreement? Is it specifically we want to make with our lawyers or patent office?
Disclosure, yeah, you should. You should properly sign an NDA before disclosing all the information.
Okay.
Because you will be giving a power of attorney to that. You need to give the lawyer power of attorney. Yeah, to work on your behalf. So yes, you must have a formal agreement in place.
Shall I have this PPT in our
yeah, it is free to share. Anyone can. Yeah.
Thank you.
Yes,
Ma'am,
Samir ji.
Next.
Yeah, tell
Yes,
me.
ma'am.
Okay, I am Deepti and I am with Dr. Manjula Jagatramka. There was a product which you said that someone is into bags, various kind of bags, and it is best to go for branding your, trademarking your brand name. So the name you get it trademark. But in our case, also my question is that we have a different kind of designing in the bags that we make. So each and every design needs to be patent. That is, the design is the same, the sizes are different. So everything needs to be patent, or just the design once can be patented?
Let me correct you first. You cannot design a patent. I mean,
no.
No. See, I am just, I got your point.
I think I can help here. That's exactly the question I had.
Sorry, I got the question actually.
Because can the designs be patented? That's the actual question. Okay.
See, that is what I'm trying to say. You cannot patent a design. There are different IP rights for different things. Patents are given only for a product or a process. Product also, which has some technical feature in it. In your case, patent is not applicable. So forget the word patent. Okay, first thing. Now comes your question in picture. So what you are trying to say is, suppose there's a design and you are creating bags of different sizes based on the design. So whether each bag should be covered under some form of IP.
Right.
Okay. So there are two IP which come in picture for your case. One is a trademark and one is a copyright. Okay?
Copyright and trademark. Okay.
So trademark will cover only your brand.
Okay.
फैब इंडिया का ब्रांड पता है आपको? फैब इंडिया.
हाँ, फैब इंडिया पता है.
आपको ये कौन सा है अपना? लावी है बैग्स में, या so many bags का मुझे I'm not recalling.
Right.
So many bags का ब्रांड्स है. वो जो बैग है, सपोज VIP है. VIP का बैग्स होता है. So VIP क्या है ना? That is a trademark. Only. Okay, वो सेम रहता है all through their product categories. ठीक है. So one thing you can do is, first आपने कोई नाम सोचा है या already some name is there, whether you have filed a trademark for it? No. So first
no, we have not yet filed it, but yeah, we have a name. We have 2-3 names shortlisted because we know that we will.
So what can happen now? The names you need to search before using or before investing pamphlets, publicities. में सब invest करने से पहले do some search on those names, whether they are already existing. Most of the time it happens that already it is registered under some category. Just give me a minute, just a minute.
दीप्ति जी, मैं मीनवाइल एक पॉइंट ऐड करना चाहूंगा। ट्रेडमार्क के ऑफिशियल वेबसाइट के ऊपर जाने के बाद आप सर्च कर सकती है आपका नाम का कोई ऑलरेडी ट्रेडमार्क किया हुआ है क्या।
हाँ, it is, the search is quite simple. If you visit the trademark office site, it is actually a very usable site. All the IP officer sites are very usable, user friendly है सारी. So पहले तो आप सर्च कर लो कि जो the names which you are planning to use do not form under any already filed ये.
Okay.
Then if it is not, then file a trademark application. Trademarks are not very expensive. Not in filing, not in prosecution, and not in maintenance as well. So better to have a trademark. Okay.
There are two things I was thinking. One is, like we have Puma or we have Nike. So there is, this visual. Right. So the visual will be there. We can have a visual, and then there is a trademark in the sense of the name, like, for everything. Suppose, we are cases to carry comfort, our product is, so there are different cases will come. So that punch line can be also trademark.
Yes. See, trademark can be a logo, like Nike का है, उसमें कुछ भी नहीं लिखा है. ठीक है. It can be Coca-Cola, जिसमें Coca-Cola लिखा है with a particular font. Okay. And it can be together a logo and some tagline, anything which forms part of it. Okay. Like that. So, yeah. So trademark is very flexible. You can design and you can file. Now coming to a question कि आपने एक डिजाइन जो बनाया है और आपको बैग्स उसमें से करनी है, तो उसके लिए you will have to go for copyright. Only the design you can protect through copyright, and then using the design you can create any size, any number of bags. And copyright also is very not very
expensive. Each design has to be copyrighted.
Right.
That's what she's saying. Yeah.
Copyright would be the proper form of IP to design. I mean, protect your design for a bag.
Thank you so much. All our queries are sorted with this. Thank you.
Thank you so much. Thanks a lot. Chalo, anyone else?
Samir Shelar. Yes, Samir Shelar. समीर जी.
हाँ, यस सर.
हाँ, बोलिए.
हाँ मैम, मेरा क्वेश्चन था, हमने प्रोसेस पेटेंट किया है और वो ग्रांट भी हो गए 2022 में. तो अभी क्वेश्चन मेरा ये था, सर ने अभी बताया था कि महाराष्ट्र स्टेट इनोवेशन में अप्लाई करके और रिफंड, मतलब जो भी कुछ फीस है, तो हम अभी अप्लाई कर सकते हैं क्या, क्योंकि पेटेंट तो ग्रांट पिछले साल में हो गया है मेरा.
Yes, Uday ji. Hello.
Sorry, I was on mute. So what I was suggesting is you go through the contents of that scheme. I mean, and then we'll have to find out. It may be possible that because now government is very eager to help startups in protecting their IP, so it may happen, but the details will have to be referred to. And I think our manager should be able to help you out with this.
Okay. Thank you.
Yes, Naman ji. Naman.
Yes, ma'am.
Hello. Yes.
Yes, sir.
Okay.
मेरा क्वेश्चन है रिगार्डिंग ट्रेडमार्क के लिए. जैसे मैंने ट्रेडमार्क अपना कोई ब्लैक एंड व्हाइट अगर मैं करवाता हूँ तो मैं कोई भी कलर में उसको ले सकता हूँ कि नहीं, उसके लिए मुझे पूछना है. मेरी प्रोडक्ट के लिए
ले सकते हैं, कोई प्रॉब्लम
नहीं. जैसे रेड में मैंने रेड फॉन्ट में अपना हमारा प्रोडक्ट है नैनो फाइबर बेस्ड सीट मास्क, उसका रेड फॉन्ट में अगर मैं प्रोडक्ट को ट्रेडमार्क करवाता हूँ तो ग्रीन या येलो में भी कोई कर सकता है या फिर हम यूज कर सकते हैं उसका?
अभी इसमें क्या है ना, I'll tell you, your base जो आपका ट्रेडमार्क का टैगलाइन है, लोगो है, जो भी है, ठीक है ना, that is already covered, whether in any color, black and white or some color, anything. See, IP का क्या है ना, IP is finally a legal right, and there will always be loopholes, there will always be people who would like to take advantage of something in the market. So iska strategy has to be evolved at every stage. So in your case, what I would suggest, black and white में आपने फाइल किया है, मोनोक्रोम है?
नहीं, अभी किया नहीं, अभी कर रहे थे जस्ट, तो मैं एक बार कंफर्म कर रहा था कि कोई भी कलर में फिर बाद में यूज कर सकेंगे कि नहीं कर सकेंगे
कर
उसको।
सकेंगे, कोई प्रॉब्लम नहीं, बिकॉज द बेसिक प्रोटेक्शन वुड बी विथ यू। जो भी आपका बेस रहेगा वो आपके साथ रहेगा, एंड देयर कैन नॉट बी एनी इशू, बिकॉज एनीवेज यू आर स्टॉपिंग अदर्स फ्रॉम यूजिंग दैट ट्रेडमार्क। सो उसमें कलर ऐड करके आपका ये प्रॉपर्टी आप यूज कर सकते हो। सो द लॉजिक हैज टू अप्लाइड। मतलब आईपी का क्या है ना, से एवरी स्टेज आपको ऐसा रेडी आंसर नहीं मिलेगा, यू हैव टू कीप ऑन अप्लाइंग लॉजिक लाइक दैट। सो यू कैन गो अहेड, नो इशू। ब्लैक एंड व्हाइट करेंगे, और इफ यू आर वेरी श्योर कि मुझे यही कलर में आगे ले जाना है एंड वेरी स्पेसिफिकली करना है, सो वो भी कर सकते हैं आप, एनी टाइप से। एंड वन थिंग आई डिड नॉट टेल इज, आई एक्चुअली skip telling, is trademark is class specific, huh?
हाँ, class.
So be very particular in which
Yes.
class you want to file the trademark.
Right.
Or it can be you can file in multiple classes as well. Suppose जैसे class 35 है, 35 is for business advertising, so वो एक generally business वालों को करना चाहिए। And apart from that, spices का, chemicals का, paints, so many classes are there. So वो थोड़ा सा एक देख लेना which class is proper for you.
Okay, thank you so much.
Welcome.
Okay, विवेक जी।
हाँ, हेलो मैम।
Yes sir, tell me.
मैम थोड़ा क्वेश्चन मेरा, एक क्वेश्चन ऐसा है कि हमने एक एप्लीकेशन, तो क्या हम एप्लीकेशन को पेटेंट कर सकते हैं?
हेलो हेलो, प्लीज स्टॉप योर।
ओके मैम, ओके सर, ओके सर, ओके सर। तो सर मेरा क्वेश्चन ऐसा है कि हम क्या एप्लीकेशन के कोड को पेटेंट कर सकते हैं क्या? क्या हाँ, मोबाइल एप्लीकेशन के।
ओके, सो मोबाइल एप्लीकेशन का आपका एग्जैक्टली आपको इसमें क्या प्रोटेक्ट करना है? वेदर यू वांट टू प्रोटेक्ट द बिजनेस आइडिया और यू वांट व्हाट एग्जैक्टली विल।
मैम आई वांट टू, हमने जो प्रोसेस बनाई है, जिस तरह से हम डेटा को प्रोसेस कर रहे हैं, जो हमने वहाँ पे एल्गोरिदम बनाया है, जो लॉजिक क्या हम उस लॉजिक को पेटेंट कर सके? भाई हम डेटा इस तरह ले रहे हैं, उसको इस तरह से ये कर रहे, यूज कर रहे हैं डेटा को।
नहीं नहीं नहीं, सी देर इज अ सेक्शन इन विच इज फॉर नॉन पेटेंटेबल थिंग्स। ओके, अभी हम पेटेंटेबिलिटी का थ्रेशोल्ड देखते हैं ना, नॉवेल्टी है, इन्वेंटिवनेस है, एंड प्लस अ वेरी इंपॉर्टेंट क्राइटेरिया इज इंडस्ट्रियल एप्लीकेबिलिटी। सो व्हाट इज इंडस्ट्री? समथिंग विच कैन बी रिप्रोड्यूस्ड इन द इंडस्ट्री कैन ओनली बी पेटेंटेड। ठीक है, सो अभी अपना जो सॉफ्टवेयर ये सब आता है ना, इन इंडिया सॉफ्टवेयर एवरीथिंग इज प्रोटेक्टेड थ्रू कॉपीराइट्स ओनली एज ऑफ नाउ। अगर आपको उसको पेटेंट करना है ना, तो यू हैव टू एम्बेड इट विद सम काइंड ऑफ हार्डवेयर। जैसा हाँ, तो देयर आर स्ट्रेटजीज, पेटेंट भी कर सकते हैं, बट उसके लिए सम what you can say, it has to be embedded with some kind of hardware, and with that you can create a patent based on that, like that. But ekdam pure algorithm based patent is not allowed.
So we have to imbibe that application with any hardware device.
Yes, yes. So some strategy people are doing this. There's no, it is not very unique. I mean, this is a common thing because everyone wants to protect the algorithms also. So there are strategies which you can use.
Okay, 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 okay.
And for mobile app का आपका जो डिजाइन है, सपोज जैसे होता है, that you can go and file for a copyright or trademark.
Yes, मैम, हम कॉपीराइट के लिए तो जा ही रहे हैं, तो मैं पेटेंट के बारे में सोच रहा था थोड़ा इसके लिए।
So this is the issue with algorithms and software based patent.
No. Okay, ma'am. Thank you.
Yeah, welcome.
Okay, वैष्णवी जी, वैष्णवी मैम, hello.
Hello.
Okay, you have a question?
Yes. Hi, ma'am. What I wanted to ask was, so I am doing a fashion startup, textile. So the brand name, I also reached out to and inquired about the, name trademarking, and I was suggested that I go for a word mark instead of a trademark. Since the brand name would be protected, तो नाम ही कोई use नहीं कर पाएगा, and they suggested two classes, I think 24 and 25. The product category जो है उसके हिसाब से. So you just said that class 35 is something everyone should do. So business advertising, as in anybody who's running a business, and like I'm running a business from
It
that
is
name, and I
advisable.
want to.
Yeah.
So if I do get that also included in my trademark, that others cannot advertise their business by the name, is that so?
See, anyways, if you file it in, two classes, but these classes now, these are ancillary classes, this support your protection actually. So if you want a very strong, robust protection, and via class 35, 34, I mean, you can go through all the classes which are given. They are very well available on the Trademark Office website. Anyone can go through it and decide because see, adding a class would add up on the expenditure as well. So that way also you have to think, because that each class has a separate application. It is not one trademark and multiple applications. Each class it is considered, or it has expenditure of a fresh trademark application. So that way also you need to think. If you think that as a startup, these two classes are enough, and then it is okay. There's no, because this is generally advisable for big industry houses or someone. Or if you are good with funds, and if you want to spend, then you can add on the class. There's no issue. And so I would like to say ki brand name or brand logo, this, like you said, like you were suggested
word mark.
Yeah, word mark. So it depends on your business strategy, like how you would like to be recognized in the market. So it's okay. There's no issue. Each and every creates value.
So what they actually suggested, like you took the example of Coca-Cola. So they've written in a certain font, they have a certain color palette. So they said if I get the trademark, then whatever logo I've designed, I'll get the symbol and the particular font and color. But someone might, use the same name in a different manner. So if you take the word mark, then you own the word itself in those classes. So nobody can at all even manipulate it in any manner and use it.
So good strategy, no issue. Every cotton cottage hai, Fab India hai, cotton culture hai. So these people are doing that. So it's okay.
Okay, so if I get the word mark, and then later on, if I do have extra funds, I can get the trademark as well and keep both.
No, trademark is a term under which a logo, a word, a design, anything can be filed. So आपका trademark ही है. It is only in the form of a word. Okay. What you are trying to say maybe is कि आप logo ले सकते हो बाद में, जैसे Nike का है या ऐसा वाला ना. So no, I don't think any need for that, because as you have a good your name itself is a trademark for you, because you are like that. So I don't think you have further need of creating a logo and all. It will
Okay, so if I get the name word marked, and then the way Nike has a right as a yes ka symbol, so that way say I have a cross symbol as my logo ahead of my brand name, so I don't need to particularly go ahead again and get that logo also trademark, because the name itself I own already.
Is it incorporated in the present application, like the one which you are trying to file? It has the word, and you can incorporate your logo also in some in some corner.
Yeah, I do have the complete logo, the symbol, the name, color, font, pura ready.
Why you want to file another one for that?
Okay, so at once only when I give it and do a word mark, I own everything, the word and the logo and everything from the word mark application.
Yes. All fall under that is your brand.
Okay. I thought word mark is like I just get the word and then logo ke liye alag se kar rahe hain, tagline ke liye.
What you have is a proper trademark. So in trademark, we are free to use, create anything of our choice, whether a word or logo or combination of these things, the colors, the design, the font, everything. So that is your freedom to choose.
So a word mark is a trademark itself. That is it.
Yes. It is
the different names confused me. Thank you.
No. So trademark is an umbrella term under which all these come.
Okay.
Yeah.
Yes, Ayush ji. Ayush Siham.
Yeah, hello, ma'am. Actually, my question was like, I am doing cutlery waste business made of like sugarcane waste. So I have not filed for like, it is a very generalized process. So I don't think like patent will be granted for the product. But my process, I have some uniqueness to make it feasible for the machine, specific machine. Hello, hello, am I audible?
Oh, yes.
Yes, yes.
Hello.
Yes, sir.
Yes, you're audible. Please go ahead.
Okay. So I wanted to know, like, should I wait for the patent to get granted before launching the products in the market, or should it?
Actually, you were not audible to me in between.
Okay, I'll say again, ma'am. Actually, my product is like my process is patentable, but I have not filed for the patent till now.
Tell me.
I wanted to know, like, should I wait for the patent to get filed and granted before launching a product, or I can launch the product in the market and side by side I can file the patent application?
You can file the patent application anytime. Like, why you want to wait till the launch? Because patents launch time, launch ke pehle, there's so many years go into the research and development of the product now. So that is a proper time when you should file a patent application. Launch is ultimate thing when you launch the product in the market. So I don't think you should wait for launch of the product. You can because your process, if God forbid someone else gets to know about your process and they file the patent application earlier. As I told, priority date is very important. First to file in India, in fact, in all over the world now, the law is first to file. I mean, whoever files first gets right on the invention. So better to, that is why there is a provision of filing a provisional patent application to get the priority. Even if you do not have the complete invention in your hands, you file a provisional patent application and you get year of 1 year's time to file the complete patent application. So because to help this issue, it's these facilities are there.
Okay.
So don't wait. If you are okay with the expenditure and if you feel that something patentable is in your hands, worth patenting, go and file a patent application. You can take advantages of so many things we have discussed here today. Any of the scheme will help you out.
Yeah, thank you.
Yes, Goke sir.
Yes. Yes, ma'am. I have a small question. I already have the trademark for my brand name for that particular category. My question is, I'm thinking of filing a patent for the process, a particular process. So I want to know how much expenditure is involved for approx.
See, Abhi, in general, I'll tell you, for a large entity, मतलब आप लोगों के लिए नहीं है ये, this is for a large entity, company है, कोई है, so on an average, a patent application filing cost 80 to 90,000 provisional, and if then you want to go for, I mean, international, I mean, there's no concept like international patent, but if you want to go for foreign jurisdictions, and that is the PCT route, then it multiplies into lakhs. So startups ke liye, there are many schemes where the government is trying to intervene to help the startup in filing the patent applications. So use those schemes, don't spend much on the filing part or prosecution part. So it is reduced multiple times when you file as a startup, but you should, I think, get yourself registered as a startup to take advantages of these schemes. But anyway, that will help you out. So better to take advantage, and it is not at all expensive if you go through this route.
Okay, and duration, as you said, depends upon how much crowd is there on particular day.
Duration we cannot predict. Any of the patent offices all over the world, duration depends on like how much rush is there in that particular category.
Minimum 1 year, if you can say.
Yes, 1 to 4 years you can say. Minimum 1, maximum 4 to 5.